much, Shane. And hello, everyone, and welcome to today's webinar session. And thank you very much for joining us and investing this short time into your business. My name is Monique Charland, and I'm the CEO of the National Franchisor Company Business Accounting Network, or better known as BAN. And as the first and leading professional accounting, business advisory, and tax franchise in South Africa, and also in our capacity as accountants and also being business owners ourselves, we have identified key areas where smaller businesses and their owners miss out on a guaranteed way to mitigate compliance risk, improve and create wealth worth having, and use the strategic advantage and competitive edge that big business does naturally. And so we would like to do some investing of our own by showing you, by way of our complimentary monthly webinars, the common mistakes we see business owners make and how to avoid them. Today, we are presenting liabilities of directors. Are you at risk of personal liability or committing a criminal offense as a director? And this is in terms of the New Companies Act. Our host for today's webinar is the proficient webinar guru, Shane Webb, who is based in Howick, KwaZulu-Natal. And I'd like to kick off by introducing our presenter this morning, Madeleine Pretorius. Madeleine is a BAN franchise owner based in Paarl in the Western Cape, and together with myself heads up technical training within the BAN franchise group. Madeleine is a qualified chartered accountant and completed her psycho articles at PricewaterhouseCoopers in Gauteng, and she is a registered CA with the South African Institute of Chartered Accountants. Just a little housekeeping before we get started. We would love to hear from you, so if you have any questions during the presentation, please type them into the question box in your control panel on the right side of your screen. You may address questions for the panel, who will consist of myself and Madeleine, at any time during the presentation, which we will then address at the end of the webinar. Our last month's recorded webinar was on directors' duties and responsibilities, and that recording is available for viewing on BAN's website, www.ban.co.za. If you click on the events menu under complimentary business webinars, and you'll find the recording under the 11th of May 2018. And to obtain a copy of today's webinar, please email BAN's head office at info@ban.co.za, and we shall email you a recording. This is Monique Charland saying goodbye until I hear from you later while on the panel. And now, without any further ado, we will cross over to our presenter today, Madeleine Pretorius.
Thanks, Monique. Thank you for that lovely welcome. Good morning, everyone, and thank you for joining us. Today's webinar, we will be having a look at the liabilities of company directors. And these are the consequences of directors for not meeting the requirements or acting in the manner that the Companies Act requires. Now, as Monique mentioned, we dealt with the duties and responsibilities of company directors in detail in our previous webinar from last month. So today, we won't be looking at those duties and responsibilities in detail again. However, I would like to just run through them quite briefly, just to give you some context before we jump right into the liabilities. Please feel free to go to our website, as Monique mentioned, download the recording if you would like to recap these duties and responsibilities. Now, a director has a duty of care and skill. He has fiduciary duties, independence of action, a duty to avoid conflict of interest, and also to prevent reckless trading in his business. And this duty of care and skill requires the director to act with the care, skill, and diligence that is to be expected from a person with the same skill and knowledge and experience as that director, and he or she will ultimately be tested against a reasonable person test. The Companies Act further then requires that the fiduciary duties of a director requires that director to act in good faith, for proper purpose, to avoid conflict of interest, and to always act in the best interests of the company. Independence of action requires the director to act independently in all situations, and once again, to always act in the best interests of the company as a whole, as well as all the shareholders, and also take a future view of the company. In other words, what actions that you take as a director will impact on the future of that company. Directors are required to avoid conflict of interest, especially financial conflict of interest. And if they cannot avoid it, they need to disclose that interest properly, in full detail, and possibly actually recuse themselves from any meetings or decisions that are taken in terms of that situation that leads to the conflict. And directors are also required to avoid reckless trading in their business. In other words, carrying on business recklessly with gross negligence, with the intent to defraud a person for a fraudulent purpose, or continuing to trade when that business is unable to pay debts as they become due in the ordinary course of trading. So as you can see from these requirements of the Companies Act, the directors are required to act in a certain manner. And today we will be looking at the consequences of not meeting those requirements. So when may a director be liable for the company's debts? Now you could argue and say, well, the company is a separate legal entity. Surely the directors and even the shareholders wouldn't be liable for the company's debts, because that's the whole reason you might have created or registered a company, is so that you can remove yourself from the liability of the company. However, the Tax Administration Act of 2011 does provide for certain instances where personal liability may arise. And this is not only for a company, but for a close corporation as well. So, what does the Tax Administration Act say? There are three instances. Firstly, if the representative taxpayer uses any amounts in respect to which tax is chargeable and they haven't yet paid that tax, or they use cash in their business and they pay for other types of things in their business instead of using it to pay tax, that representative taxpayer could be liable for the tax liability that is outstanding. So what is a representative taxpayer? A representative taxpayer is the person who is responsible for paying tax of the company and who is acting as an agent on behalf of the company to SARS. So this is usually the director. And it would be the public officer that is designated on your registration form where you initially registered as a taxpayer, the company registered as a taxpayer with SARS. There you would have had to actually include a person as a public officer, and that is the representative taxpayer. So you can see that person takes on quite a bit of responsibility, because if tax remains unpaid, but the business carries on and funds are being used, or salaries are being paid, or dividends are being distributed, that representative taxpayer could be liable for the tax debt of the company. Secondly, if a person dissipates the assets of the company to obstruct the collection of tax debt due by that company, they could also be liable for the tax liability. And here I'd like to just emphasize that bold where it says in the Act a person. So it doesn't specify that this person just has to be a director. Any person who actually does this and obstructs the collection of tax debt would be liable for that liability. So it could be an employee, it could be one of the shareholders, it could be anyone who is party to that transaction, so to say. And thirdly, if a person who controls or is regularly involved in the management of the overall financial affairs of the company, if they were negligent or fraudulent in the payment of the tax debts of the company, they could also be held liable. And here you can see the Act actually specifies it a little bit more, because even though it says a person, which is quite broad, it does specify and say it's that person who controls or is regularly involved in the management of the company. And that would then usually be either a director or possibly a shareholder if you are an owner managed business. And it's interesting to see, but what the Act actually says is that a shareholder, say for example, just to give you an example, could be liable for the tax debts that were due by the company almost a year after the winding up of the company, if they received dividend distributions at the time that the tax was outstanding. So you can see that it actually has further consequences, or it is actually a longer term that you would expect. So it's very important that you make sure that your tax is paid first, if that is at all possible, before obviously paying other amounts in your business. Looking at the personal liability of directors, so coming back, so stepping away from the debts of the company and looking at the director himself, we're first having a look at delictual liability. So a director could be liable for any loss, damages, or costs sustained by the company as a consequence of certain types of action that the director can take. And what are these? Let's have a look at them. First of all, any breach of any of the provisions of the Act or the company's memorandum of incorporation. So as we mentioned in our previous webinar when we looked at the duties of directors, these responsibilities of the directors have now been brought into the legislation. They are now part of the provisions of the Act. So if you as a director don't act in the best interests of the company, or you breach your fiduciary duties, then you are breaching the provisions of the Act and you could be liable for any losses or damages sustained by the company in your personal capacity. And then also the company's memorandum of incorporation. I'd like to pose the question, do you know where your company's memorandum of incorporation is? And if so, do you know what its contents are? Because if you are not aware of the provisions in your MOI, then you could possibly be in breach of those provisions without you being aware of that. And you could be liable for loss or damages that could be sustained by the company because of that breach, and you might not even be aware of it. So that's extremely important to know what is cooking in your MOI. If a director acted in the name of the company while knowingly lacking the authority to do so, in other words, he's exceeding his powers, he could also be liable for loss. If the director agreed to carry on the company's business, knowing that it was being conducted recklessly or with gross negligence, with the intent to defraud any person or for a fraudulent purpose, or while the debts of the company remain unpaid and they are unpayable, and as they become due and payable in the normal course of business, that director could be held liable for the fact that this company is trading recklessly. If the director is party to an act or omission, despite knowing that the intent was to defraud a creditor, an employee, or a shareholder, or the act was for a fraudulent purpose, he could also be held liable. And in terms of financial statements, if any financial statements or management accounts were signed or authorized for publication, but they were false or misleading in a material respect, this could also lead to a personal liability. Now, interesting to note is that it's not always necessarily an intentional criminal act or an intentional act that the director needs to make for the company to end up or for it to default into recklessness. It might be that you're busy trading and you may be not aware that you are going in the wrong direction. So it's extremely important to know what the financial position of your company is, to have the financial information available as a director to be able to make decisions. Because the intention of the Companies Act is to ensure that the directors only act when they have all the information they need for decision making and they know what's going on, so to say. So it's extremely important, once again, that your management accounts or your accounting records are up to date. Because as a director or someone who is responsible for managing the company, it's really difficult to make decisions and to make sure that you're in compliance with the Act if you don't have the information that you need or up-to-date and complete accounting records. I'd also like to just go back to this highlight here, this bold, the material respect. So when we look at financial statements being false or misleading, the Act specifies that it will only lead to a liability for a director if they are false or misleading in a material respect. Now, what does that mean? You could actually ask that question. Now, materiality is usually a calculation that gets done by your accountant. It takes into account certain factors that are company specific, so that materiality amount will be unique to each company. And it is basically an amount above, it's usually a rand value, and it's an amount above which any errors or misstatements would create your financial statements, if I can say, to be no longer useful for decision making, if that makes sense. So it would actually result in your financial statements no longer being useful to the users of those statements, so whoever reads those financial statements. And that is why the materiality is there, because anything below that might probably not be a cause for concern. But just to remember as well, that your materiality is not always just a rand value. It could be qualitative in nature as well. So we could have a situation where it's a very small rand value. There might be an error in your financial statements due to a small rand value, but it could be because of fraud or possibly theft or something like that. And because of the very nature of that, it becomes material. So it's just important to remember that as well. If we go back and look at the debts of the company becoming due, and the company not being able to pay them, but still continuing to trade. Just remember also that these debts that we talk about are not just loans and long-term debts and things like that. It also looks at creditor payments, it looks at SARS payments, possibly if you have rentals in the business that you might need to pay. So it's anything that the company has an obligation to pay. And if you are in a position that you can no longer meet those obligations, then you need to be very, very careful because you might be going into reckless trading without actually intending to do so. So the director in this case will be held personally liable to the company, but also any outside stakeholder that is affected. So your creditors could also possibly institute a claim against the director. Let us move on to your criminal liability or sanction. So there are various instances in the Act where you could be guilty of an offence. Firstly, we will look at accounting records. If a director or any person falsifies a company's accounting records, fails to keep accurate and complete accounting records, does not keep accounting records in the prescribed manner and form per the Act, or permits any other person to falsify accounting records, or is a party to an act or omission intended to defraud a creditor or employee, that director or person could be guilty of an offence. Now, the Act specifies that it's not only a director in this case, it could be any person, and any person would be anyone who is responsible for, say, the accounting records or dealing with them. So it could be an employee, it could possibly be a shareholder, not necessarily just a director, or if you have been designated as a director. The Act also mentions prescribed manner. Now, the prescribed manner usually refers to the requirements set out by the international accounting profession, and the accounting records are required to be of such a quality and to be prepared in such a way that you can actually set up your financial statements from those accounting records, and then as a result of that, meet the requirements of the financial statements that the Companies Act also wants you to do. So it's important that your company accounting records are accurate, complete, and up to date. It's so, so important, and we actually see that there's widespread non-compliance in the SME market with this. Because a lot of small businesses almost put the business first and the admin later. And from this session today, I hope that the importance of the accounting records kind of shifts up a notch in terms of the business priorities. Because without these records, without management accounts, you as a director or an owner-managed director of your company, you are unable to make decisions if you do not have the information available. You won't be able to calculate your liquidity and solvency test or even enable your accountant to do that for you. So your accounting records, as you can see, not only are important for decision making, but also could lead to a criminal offence. Moving on to the financial statements. If any person is party to the preparation, approval, or publication of any financial statements, including management accounts, that are materially false or misleading, or do not materially comply with the requirements of the Act, they could also be guilty of an offence. Here the Act once again refers to any person, so not necessarily just a director or someone who has been designated as a director, but it could be an employee as well. If they are party to materially false or misleading financial statements, or they don't comply with the requirements, then they could also be guilty of an offence. And once again, we look at the materiality concept that we explained a bit earlier. Now, what are the requirements of the Act for financial statements? Firstly, the financial statements must satisfy the financial reporting standards if such standards are prescribed. And in most cases, this would be your IFRS for SMEs, which is an international accounting reporting standard. The financials must also present fairly the state of affairs of the company In other words, the financial position, the trading results, any transactions with shareholders or cash flow position of the company. It must show the assets, liabilities, equity, income, and expenses, and any other prescribed information. For example, additional disclosure notes or more information about transactions, possibly additional cash flow or a director's report. The financials should set out the date on which the financial statements were published, as well as the accounting period covered. Because if you had a change in year-end, possibly, the accounting period could be shorter or longer than a normal 12-month financial year-end. And that needs to be specified so that whoever reads the financials understands what they are actually looking at. And there should also be a prominent notice whether the financial statements have been audited, independently reviewed, or if neither are applicable, as well as the name and professional designation of the individual who prepared or supervised the statements. And this requirement is very often overlooked. And as you can see, it's quite a serious requirement because you could be guilty of an offense if that is not in your financial statements. A company could also be guilty of an offense if they don't provide their full registered name or registration number on demand, or they use their name or registration number to mislead or deceive any person. If an interim name has been issued to a company by the Commission and they do not use that name until their actual name has been amended, they could also be guilty of an offence. And if your registered name and registration number are not on all the company's official publications, documents, and notices, or if you fail to grant access to any record that a person has a right to inspect or copy, then the company could be guilty of an offence. The Act also then in the same section specifies that any person who uses the name or registration number of a company or a form of the name that creates the false impression that it is the actual name of the company, and then uses that name in such a way that it conveys the impression that the person has authority to act on behalf of the company when they actually in fact don't, they will also be guilty of an offence. So this is actually quite an interesting one because it's not necessarily just a director, it's any person. It could be an employee who misuses, so to say, the name of the company, or it could be an outside party in terms of a situation almost like identity theft. So here, the distinction we can see is the company. So if the Act specifies the company, it's usually the directors because they are accountable for the acts of the company. But if it refers to any person, that could be any outside person as well. Every company is also required to prepare annual financial statements, and these financial statements are supposed to be prepared, done and dusted within 6 months after the end of its financial year. That is a Companies Act requirement, so it's been legislated, but it hasn't always necessarily been followed up. However, a recent High Court judgment ruled in favor of the Companies and Intellectual Property Commission, or CIPC, levying administrative fines for contravention of this specific section of the Act. And that administrative fine amounted to 10% of turnover during the period that the company was non-compliant. And that could actually end up being quite a large amount, 10% of turnover. So we're still kind of waiting to see how CIPC is going to be monitoring this and actually enforcing this. But if you are a company that is entitled or is required to be audited, the auditors are entitled to report this contravention, possibly also if you are under independent review. So even if you are not necessarily being audited, it's important to be aware of this penalty that could actually come up, because it could end up being a large amount. And once again, you can see that if you want your financial statements to be signed within 6 months after your year end, one of the most important things that you can do is to have accounting records that are up to date and ready to go so that you can just complete those financial statements shortly after year end. This fine is seemingly becoming more important because they are actually enforcing it more and more. So it's something you must please be aware of and possibly look at the state of your affairs and your accounting records to see if you can actually comply with this. Another recourse against directors, or to protect interested parties against directors who are not acting in the manner required by the Companies Act, is the delinquency of directors. So any interested party, for example, the company, shareholders, fellow directors, the company secretary, even the trade union representing employees could actually apply to court for an order declaring a person delinquent or under probation. So when could this happen? If you consented to serve as a director, but you knew that you were ineligible or disqualified under the Act, or you were still under probation order, if you grossly abused the position of a director, if you intentionally or with gross negligence inflicted harm on the company, or you acted in any manner amounting to gross negligence, willful misconduct, or breach of trust in relation to the performance of the director's duties, or if you used your position as a director or any information obtained while acting in the capacity of a director to gain a personal advantage. So you can see just by reading the circumstances that could apply that the delinquency order is really for quite serious misconduct. It is not necessarily for ordinary commercial misjudgment of your directors, so making an honest mistake or something like that. It's really for serious misconduct. It's for those directors who are really not acting the way they should. And it's interesting to note that if it's an extremely serious misconduct, this order could actually apply to you over your lifetime. So it could potentially be very serious. What are the consequences of a director then being made delinquent? Well, you would be disqualified from acting as a director. You may be ordered to pay compensation to anyone who suffered loss as a result of that. You may be forced to be supervised by a mentor if you want to participate as a director in future. Or you could be limited to only serve as a director of a private company or a company of which you are the sole shareholder. But I think more than that, think about the reputational damage that this might cause. If you're declared delinquent, I would really not expect you to possibly act as a director ever again because of the reputational damage this might cause. So this is a potentially very serious consequence of not acting in the manner prescribed by the Act as a director and not acting in the best interests of the company. I'd like to just show you a few examples because delinquency of directors has actually come up in recent case law quite a lot, which shows that these orders are being ruled more and more, and there are more and more applications against delinquent directors being submitted. Before I just look at the list, I actually want to highlight point number 8 for you first. In a recent case ruling, the director was declared delinquent for failing to keep accounting records of the company. So the emphasis that we've been placing on accounting records has actually been highlighted in our case law as well, because you might actually end up being declared a delinquent director if you don't keep accounting records of the company. And it seems like such a simple thing. If you look at the rest of the list, you can see that for our SME market, it could actually be quite applicable. For example, allowing money for the company to be paid into account other than that of the company's account, not detecting fraud in the company and reporting it to SARS, or using the funds of the company for the benefit of other companies, or paying yourself or the fellow directors unlawful and extravagant directors' fees, or unlawfully making loans to a director on behalf of the company, or using the company's funds to pay for personal legal fees, or failing to hold an annual general meeting. If you are an owner-managed company, you might think to yourself, well, is it really necessary to hold an annual general meeting? Well, possibly not, because you are the shareholder and the director. However, it might be a good idea to just go and document the fact that you have considered certain issues in the manner prescribed by the Act. Once again, it's extremely important to note that you cannot make informed financial decisions without accurate and up-to-date management accounts, and these should include both your balance sheet as well as your income statement. And if you think that, well, how would a person actually know that you are not acting in terms of the Act and that you are possibly contravening the provisions? If you're a small business or you're owner-managed, how could they possibly know? Well, the Promotion of Access to Information Act states that shareholders automatically have access to the accounting records of the company, but anyone else, any other interested party, could request access for a fee. So if you have a person, say for example, a creditor, who has a vested interest in something that happened with regards to your company, they could actually request your financial statements or your accounting records, and if they are not available, they might be able to apply to court for an order to declare you as the director delinquent. So it's extremely important to be aware of that as well. Directors might also be in a situation where they could be charged for double liability. In other words, they are liable simultaneously for the same offense. But how is this possible? You could ask, why? Why does this happen? Well, directors are accountable to the shareholders because they act as an agent for the shareholders and act on behalf of the shareholders with the company, as well as the directors being employees, trustees, and officers of the company. In other words, they're also acting in a fiduciary relationship to the company. And those two relationships that the directors have could actually create more than one liability for them. Let us look at a scenario to illustrate this. Ben Eager, a director of Superco Pty Limited, allows his company to receive goods on credit from Easy Supplies Pty Limited. However, Ben knows full well that Superco Pty Limited, or the debtor company, is not in a position to make payment for such goods. So he's bought goods on credit, but he knows he'll never be able to pay them. Such conduct would constitute reckless behavior on the part of Ben, and it may also include an intent to defraud the creditor, because Ben knew that he would never be able to pay. So Ben opens himself up to a personal liability claim. And let's have a look at how that liability could arise. Superco, or the debtor company, can pursue a civil claim for loss or damages against Ben. But Ben is also liable in terms of his breach of fiduciary duties as a director. And per the Act, any person can pursue any other person for loss or damages as a result of contravention of the Act. In other words, the shareholders may institute a civil claim against Ben for any loss or damages, and the creditor, Easy Supplies, could also pursue a claim for loss or damages against Ben, but also against the company. And Ben may also be charged criminally for fraud. The Act provides that any person who committed fraud or perpetrated fraud in relation to a company, its creditors or employees is liable for criminal liability. And the Prevention and Combating of Corrupt Activities Act says any person who comes to know or suspects of fraud, they actually have to disclose that fraud to the authorities or to the police or to a police official. And if they don't do so, it would be a criminal offense. So in this case, the creditor has a statutory duty to report fraud or suspicions of fraud, because Ben carried on the business with the intent to defraud the creditor. He acted recklessly, and the creditor can then go and actually report that in terms of a criminal liability. So, as you can see from the example, the directors of debtor companies may not only be held personally liable towards the company and its shareholders, but also to its creditors for losses incurred, and also in a criminal manner as well. You may then ask, what can a director do to defend himself against liabilities? What can he do? Well, first of all, obviously, he could strive towards not contravening the Act. But there are three courses of defenses that the directors can actually follow. First of all is the business judgment rule. Now, the business judgment rule is to prevent directors being held liable with obviously the benefit of hindsight for honest errors of judgment. So if a director acted with due care and skill, he acted in the best interest of the company with independence, and he fulfilled his fiduciary duties, he shouldn't really be held responsible for something that happened in the company. So the business judgment rule basically says that for any matter that arises as this director performs his function, he is entitled to rely on the performance of certain persons, and he's entitled to rely on any information, recommendations, financial information, anything like that, that have been prepared or presented by any specific persons. There are three requirements that need to be met in order to be protected by the business judgment rule. The director must have made an informed decision. In other words, he needs all the information regarding the situation, complete and accurate accounts or management accounts to be able to know what the financial position of the company is. There must have been no self-dealing or self-interest, but if they were, there should have been proper disclosure of any material interest, and the director should possibly recuse himself from that situation. And there must also be a rational basis for believing that the director was acting in the best interest of the company. He must be able to demonstrate that. Only then will the business judgment rule be applicable, when the overarching requirements of duty of care and skill have been met, as well as these specific requirements. So the director is therefore entitled to rely on competent and professional persons to help him to do his work. So who can he rely on per the Act? Employees of the company, if he believes that they are reliable, competent, and are able to give him accurate information. Possibly fellow directors, if that is applicable, if the matter under question is that person's professional or expert competence. Possibly a board committee, but that's usually in very large companies. And also legal counsel, accountants, and other professional persons. So the Act requires, with regards to other professional persons, that they should have been retained by the company. In other words, there must be a signed proof of this, like a terms of engagement or a mandate that sets out the responsibilities and scope limitations of this professional. And they should also have been retained specifically with regards to the matter at hand. So they should have the skills or expertise to actually be able to assist the director, and the director must believe that they have expert competence. So throughout this section, the Companies Act refers to merits confidence. In other words, whoever the director relies on should merit confidence that they know what they're doing. So the director must have a feeling of, this person can actually help me, they are an expert, they have the competence, and they know what they're doing. So the director cannot hide behind the reliance of expert opinion. It is still ultimately his decision to make. It is still ultimately his judgment. He must exercise due care and skill, but he can actually get assistance. When, however, will directors not be protected under the business judgment rule? If the director did not meet the duty of care or skill, or did not act in the best interest of the company, then he would not be protected. And a new duty has been imposed on directors with a second requirement. Any director who is not acquainted with the financial affairs of the company, allowing the company to continue trading when it is unable to pay its debts as they become due and payable in the ordinary course of business, will not have a defense under the business judgment rule. And hopefully you can start seeing almost like a familiar trend coming through the Companies Act. They keep referring to reckless trading, making sure that the directors know what the financial affairs of the company are, knowing that your accounting records are up to date, and being able to pay your debts as they become due, and not continuing to trade if you know that you cannot. So you can see it's almost like a theme coming through the Companies Act. So the directors need to identify and recognize the stage at which the insolvency of the company is imminent. They need to know what is their liquidity, what is their solvency position. They have a statutory duty, thus, to know what the financial position of the company is. They cannot remain ignorant of the financial affairs of that company. And that is why it is so important, and why I'm emphasizing the fact that you need company management accounts and accurate and complete financial records. If proceedings have been instituted against a director and they are not for willful misconduct or willful breach of trust, then the court may relieve that director for his liability if it is found that he acted honestly and reasonably, or it would be fair to excuse that director if they look at all the facts and circumstances of the case. So usually the courts would use a reasonable person test, taking into account the director's knowledge as well as the access to the information he had, to determine whether he actually did act with proper purpose or if he should be held liable. So you could apply to court for some relief. A company could also use indemnification insurance to protect a director. So a company may purchase insurance to protect either the director or the company itself against any liability or expenses for which the company is permitted to indemnify a director. So that is an alternative to defense for directors. However, please be aware that there may be restrictions on indemnification in your memorandum of incorporation. So once again, it's extremely important to know what is in your memorandum of incorporation, because it might actually affect your liability. Hopefully, through today's session, you have become aware of the importance of acting for a proper purpose as a director in the best interest of the company, and the potential liability or serious consequences that could arise if you actually don't do this. So there's an increased awareness overall in terms of the courts and applying the Companies Act in terms of how the directors are acting. And we are seeing increased liabilities or personal liabilities of directors. So hopefully this session will encourage you as a director to ensure that you are compliant, that your accounting records are up to date, and you could hopefully prevent any personal liability as a result of that. Please join us for our next client webinar. We are moving towards the Closed Corporations Act, looking at the responsibilities of members, so moving away from directors and now looking at members. This session will be on the 13th of July, same time slot, 9 to 10, and it would be lovely if you could join us. Are there any questions? Please feel free to send through your questions and we could possibly clarify certain items for you. For those of you who might not be able to see, James, thank you for your question. He writes, how does one justify paying staff instead of SARS in a particular month or months? Without staff, there is no business. There is clear indication that the business will improve to the extent that the debt to SARS can be settled at a later stage. Well, James, thanks for your question. That's a very good question. And I would tend to agree with you. Without your staff, there is no business. I think this is specifically for cases where tax remains unpayable or due for quite extended periods of time, and the company kind of continues trading without paying those tax liabilities. So if you have a particular month where you see, oops, you might be a little bit cash strapped and you're paying your salaries instead of your SARS liability, as long as you actually do pay that SARS liability within due course, and you know that you are able to pay it in the future of your business, then I think you should be all right. But just remember, then you might actually be liable to SARS liabilities, penalties or interest, because you might actually be paying them late. I think this is specifically for cases where the directors were actually grossly negligent, or they actually were fraudulent in not paying their tax.
Also, what taxes one is actually referring to when you can't pay SARS. So when it comes to employee tax, clearly you are, as a director, deducting the tax from the employee's remuneration in a fiduciary capacity and holding that in a fiduciary capacity to pay SARS. So that should be first and foremost a tax to be paid over to SARS. The second one is VAT. Now, for small businesses, we understand the cash flow that the VAT Act relates to in terms of having to pay over VAT on an invoice basis when in fact you haven't received the monies yet from your customers. And this can be quite a tight squeeze at the end of the month when VAT is due. So my tip here is to have a call account and put as much money away in that call account and take it out of your operating account for VAT when VAT becomes due. In that specific instance, there might be a justification when you don't have the cash flow because your customers haven't paid you the VAT. And the following month they might pay you and you may be able to pay it over. But what we see a lot in these small businesses is that it continues to be a trend and it accumulates month after month. And then you have a situation when your business is definitely has probably a negative liquidity. And that is when you've got to be very cautious in terms of the liabilities or the personal liability of the director. And then the third tax is the income tax of the company. And just a tip here is if you're getting management accounts every month or every second month, I know with the BAN accountants, we will always let you know what your tax provision needs to be every month in relation to the profits of that company. And my tip here is to open up a second call account and put that money into a tax provision account. In other words, take it out of your operating account, put it into a call account so you don't utilize that money for operating expenses. And hopefully that is going to help directors in financially managing their businesses more properly and avoiding the either the delinquent director court cases or obviously personal liability from SARS. Thanks.
How does business rescue affect the potential liability of directors who have been trading in insolvent circumstances prior to business rescue? Keith, I think actually the fact that they are going into business rescue is a positive part in terms of the directors. But if they were trading under insolvent circumstances prior to business rescue, and they actually did that for a period without notifying their creditors and things like that, they could still be liable for that period that they traded recklessly. So I would think that usually under business rescue proceedings, all that would come to light, and they would actually consider whether the directors acted responsibly and instituted business rescue in time, or if they actually tried to kind of hide the fact that they were having solvency problems and that business rescue was possibly forced upon them. It depends also, I think, on the facts of the case and the circumstances, and the courts or the liquidator would probably have a look at that as well. Hopefully that answers your question. Monique, do you have any input possibly for that?
Thanks, Madeleine. No, I don't. I think you covered that very well. Thanks, Madeleine. To Madeleine for a brilliant presentation once again, and thank you to Shane as well for brilliant hosting. And I do look forward to everybody participating in our next webinar series, or our next webinar next month, which is going to be mostly focused on closed corporations and the responsibilities and duties of members, as well as potential criminal liabilities of members of closed corporations. So I look forward to seeing everybody next month.